So good day everyone. Today I'm going to introduce to you what is Republic Act number 10586. So it is an act penalizing persons driving under the influence of alcohol, dangerous drugs, and similar substances and for other purposes. So under the declaration of policy, the state shall penalize the act of driving under the influence of alcohol, dangerous drugs, and other intoxicating substances, and shall inculcate the standard of safe driving and the benefits that may derive from it through institutional programs and appropriate public information strategies. So basically, this law was made to prevent accidents and to preserve the life of every road users, and that anyone who violated this law might be held accountable in the different liabilities that may be incurred by the court. So, what do we mean by alcohol? It refers to the alcoholic beverages classified into beer, wine, and distilled spirits, the consumption of which produces intoxication. So basically, it refers to anything which might intoxicate a person's mind and its action towards something, including his decision making. So let's move on to breath analyzer, which refers to the equipment which can determine that the blood concentration level of a person through testing of his breath. And then under the chemical test refers to breath, saliva, urine, or blood tests to determine the blood alcohol concentration level and or positive indication of dangerous drugs and similar substances in a person's body. So let's move on to dangerous drugs and other similar substances refers to drugs listed in the Schedule Annex to the 1961 Single Convention on Narcotic Drugs as amended by 1922 Protocol, and in the Schedules Annex to the 1971 Single Convention of Psychotropic Substances as enumerated in its attachment, which is an integral part of the Republic Act number 9165, otherwise known as the Comprehensive Dangerous Drugs Act of 2002, and those that the board may reclassify and to add or remove from the list of the dangerous drugs. So to sum it up, dangerous drugs are other similar substances which might intoxicate also a person's mind, which might affect his decision making and the way he handles a certain situation. So what do we mean by driving under the influence of alcohol? It refers to the act of operating a motor vehicle while the driver's blood alcohol concentration level has, after being subjected to a breath analyzer test, reached the level of intoxication, as established jointly by the Department of Health, the National Police Commission, and then the Department of Transportation and Communications. On the other hand, driving under the influence of dangerous drugs and other similar substances refers to the act of operating a motor vehicle while the driver, after being subjected to a confirmatory test as mandated under the Republic Act number 9165, is found to be positive for the use of any drugs. So under the Section 5 of Republic Act 10586, under Punishable Act, it shall be unlawful for any person to drive a motor vehicle while under the influence of alcohol, dangerous drugs, and other similar substances. So under Section 6, the conduct of field sobriety, chemical and confirmatory tests, a law enforcement officer who has probable cause to believe that a person is driving under the influence of alcohol, dangerous drugs, and other similar substances by apparent indications and manifestations, including overspeeding, weaving, lane straddling, sudden stops, swerving, poor coordination, or the evident smell of alcohol in the person's breath, or signs of use of dangerous drugs and other similar substances, shall conduct field sobriety tests. Under Section 7, it is the mandatory alcohol and chemical testing of drivers involved in motor vehicle accident. So basically, Section 7 simply implies that every vehicular accident needs to go under different types of tests. So under Section 10, deputation, the LTO may deputize traffic enforcement officers of the PNP, the Metropolitan Manila Development Authority, and cities and municipalities in order to enforce the provision of this act. Under Section 11, law enforcement officer education, the LTO and the PNP shall conduct training seminars for their law enforcers and deputies with regard to the proper conduct of field sobriety tests and the breath analyzer test every year. Within 4 months from the effectivity of this act, the LTO shall publish the guidelines and procedures for the proper conduct of field sobriety tests, which guidelines shall be made available to the public and made available for download through the official LTO website. So under Section 12, under penalties, a driver found to have been driving a motor vehicle while under the influence of alcohol, dangerous drugs, and other similar substances, as provided for under Section 5 of this Act, shall be penalized as follows. Number 1, if the violation of Section 5 did not result in physical injuries or homicide, the penalties of 3 months imprisonment and the fine ranging from 20,000 pesos to 80,000 pesos shall be imposed. And then the second one, if the violation of Section 5 resulted in physical injuries, the penalty provided in Article 263 of the Revised Penal Code, or the penalty provided in the next preceding subparagraph, whichever is higher, and the fine ranging from 100,000 pesos or 200,000 pesos shall be imposed. So to sum up the Section 12, if you did not incur physical injury to the victim, then you might only be imprisoned by 3 months and you might need to pay for 20,000 to 80,000 pesos. On the other hand, under the paragraph 2, if it resulted in physical injuries or death, you might need to pay for at least 100,000 to 200,000 pesos, as provided by the Article 263 of the Revised Penal Code. Under the paragraph 3 of the Section 12, if the violation of Section 5 resulted in homicide, the penalty provided in Article 249 of the Revised Penal Code and the fine ranging from 300,000 pesos to 500,000 pesos shall be imposed. And under the last paragraph of Section 12, the non-professional driver's license of any person found to have violated Section 5 of this Act shall also be confiscated and suspended for a period of 12 months for the first conviction and perpetually revoked to the second conviction. The professional driver's license of any person found to have violated Section 5 of this Act shall also be confiscated and perpetually revoked for the first conviction. The perpetual revocation of the driver's license shall disqualify the person from being granted any kind of driver's license thereafter.